Hi everyone and welcome to episode 5 of the WHorld of Employment Law. I'm Gemma and I'm a solicitor in our employment team, and I'm joined by...
I'm Adam, I'm also a solicitor in the employment team at Wright Hassall.
So we were thinking about what topic to do for today's podcast, and with the next quarterly employment tribunal statistics due to be published soon, we have been looking through the previous ones in preparation. And what we've noticed is that tribunal claims have seemed to be decreased on prior years. Now, caution has to be taken in looking at that result on the basis of the pandemic, obviously impacting the results for a couple of year period, with extra claims of furlough being introduced, and also the disruption with the transition of a new database for the employment tribunal. But when looking at the types of claims still being brought, discrimination claims are still a key one in the employment tribunal, and they can be raised by employees, workers, or self-employed individuals. Now, looking at that, we're also looking at the inquiries we get within the team, and we're thinking that that tends to be reflected as well. So in terms of the topic, we thought, why not have a bit of a discussion about discrimination in the workplace and potential pitfalls employers are falling into, as well as employees, in terms of banter mixing with discrimination in the workplace, and where potentially should the line be drawn with those.
So it's probably a good place to start to actually set out what discrimination is in law. Lots of people have heard the term discrimination, but actually it has a very specific meaning in law and actually is perhaps far wider than most people realise. So broadly, discrimination occurs when an individual is treated less favourably because of what are known as protected characteristics. Now, I'll go through protected characteristics in a moment and what they are, but there are actually six types of discrimination. There isn't just one single claim of discrimination, and we're going to go through each of those as part of this podcast. So there are only certain characteristics that a person can have, or attributes that are protected under the Equality Act. So they are, and we're only for the purposes of this podcast going to go through them very briefly, because we could do a podcast just on these characteristics. They are age, disability, gender reassignment, which is perhaps more commonly known as being a trans person, marriage and civil partnership, pregnancy and maternity, race, religion or philosophical belief, sex and sexual orientation. That we see is indirect discrimination. Now, indirect discrimination is perhaps one that solicitors such as ourselves would identify for clients rather than them identifying them themselves, because they can be a little more tricky to identify than direct discrimination. So indirect discrimination is where there is a provision, criterion or practice, is how it's referred to within the law. So that is policies, working practices, routines, shift patterns, that sort of thing. And those must apply to everyone, not just the person bringing the claim. But that PCP, as we call it, must adversely affect people with one of those 9 protected characteristics more than others, and that difference or adverse effect cannot be justified by their employer. So quite a tricky one to comprehend. So to give an example, so a school might have a policy where teachers have to move to their next classroom within 5 minutes of the sounding of the bell. So that applies to all teachers equally, but disabled teachers may struggle to get that quickly to different classrooms, and therefore that policy would have an adverse impact on them because they couldn't comply with it.
So another type of discrimination claim is harassment. Now, lots of people again have heard of that word, but whether they necessarily know the legal definition of harassment under the Equality Act. So the legal definition for harassment is unwanted conduct which has the purpose or effect of violating someone's dignity or creating an intimidating, hostile, degrading, humiliating or offensive environment for them. So the key impact, which it is in a lot of discrimination claims, is the impact on the individual and how they felt by potentially comments being made towards them, or things in writing, or even actions or omissions. So it's quite wide ranging. and people often forget that it can be written down, or it could be through not doing something. So potentially excluding a colleague at work on the basis simply of their age, if they were slightly older than the rest of the team and the team decided to go on lots of nights out together and didn't invite their colleague simply because they were slightly older than them and fell into a different age group, that could potentially create that employee to feel intimidated or humiliated or offended based on the actions they made, especially if there were comments made alongside that. So that tends to form into the view of harassment. Now, harassment tends to be where there is more than one incident, but that doesn't have to be the case. Harassment can occur when there is simply one incident as well.
So another word that is perhaps misunderstood by claimants in claims that we see is victimisation. We see lots of claims where claimants are saying they have been victimised, but actually they don't realise that in law, victimisation has a very specific claim. So when they're using that word, they probably mean something else. So victimisation in the Equality Act is a retaliation against someone who has complained against harassment or discrimination in the workplace, or has supported someone who has complained of discrimination or harassment. So to give an example of that, if Gemma was to claim that another member of Wright Hassall had discriminated against her, she was to raise a grievance about that and said during that grievance, speak to Adam, Adam can support what I'm saying. If I then helped with that grievance process and then a week later I was invited to a meeting saying that my performance wasn't up to scratch, then that could be a retaliation against me trying to assist Gemma with her grievance. So that would be an example of victimisation.
So as Adam mentioned previously, discrimination claims are related to protected characteristics. Now generally, and the four types of discrimination we've just talked about, is where there's a characteristic that the individual raising the claim possesses themselves. But discrimination can also occur where the individual doesn't possess the characteristic themselves. And there are a couple of claims that we'll just talk through briefly as well for that. So there is associative discrimination. So this is where an individual is treated less favourably, not because they possess a protected characteristic, but because they're associated with someone who does have a protected characteristic. So an example of that will probably make it a bit easier to understand. But if a male colleague isn't offered the same training opportunities as other people within the team, and the basis of that is because their wife is pregnant at the time and the business just decides they wouldn't have the time to come and attend the training courses because they need to be at home looking after their wife or things like that, if the courses are potentially outside of working time or during time where they think they need to devote towards their wife, then he could potentially bring a claim for associative discrimination for suffering the detriment of not being given that same opportunity as his colleagues.
And the final of the 6 types of discrimination is perceptive discrimination. So this is where actually you're subject to less favourable treatment because someone else has mistaken that you have a protected characteristic which you don't. So as an example of that, for instance, an employee might not be offered a new role within a business or a new job completely because the employer or the interviewer assumes that she is pregnant when she isn't. And I think that example, as well as being perceptive discrimination, it illustrates actually to bring a discrimination claim, claimants don't actually have to be employed by the company that they are bringing that claim against. It's a day one right, but actually it's an interview stage, an application stage. Discrimination claims can be brought for the whole life of an employment relationship. So, having been through a whistle-stop tour of the 6 discrimination claims and also the protected characteristics, to move on to banter. Banter, unlike discrimination, is not set out anywhere in law what that means, and therefore there's quite a wide scope for how it interacts with discrimination. Now, you don't need me to tell you what banter might mean, but it can be joking, it can be teasing, it can be lightheartedness, which actually can go too far, and that's when we look at discrimination claims. Now, as there is no line between banter and discrimination because it isn't contained in law anywhere, it often depends on the individual circumstances. So it's difficult for me and Gemma to say to you all when something is banter and when it is discrimination. But one thing we can say for certain is that if that banter doesn't relate to a protected characteristic or a perceived protected characteristic, then that can't be discrimination. But that doesn't mean that there's no legal claim at all. There are other claims that people might bring on the back of banter getting out of hand in a workplace. So that could be raising grievances, which could then lead to unfair dismissal claims on the basis of a breakdown in trust and confidence. So just because a protected characteristic isn't involved doesn't mean that employers aren't at risk. Now, we're not here today recording this podcast to discourage banter at all in the workplace. We aren't saying that it should be banned and advocating for a sterile environment. Banter in positive terms can allow colleagues to get to know each other better, it can build team morale, it can make workplaces more fun and encourage employees to want to attend the office, and it can also improve inclusion within a business. But obviously the opposite is true, and that's something that Gemma is going to talk about in a moment.
So in terms of looking at discrimination and banter, as Adam said, there isn't necessarily that line which can be drawn, but where things do cross over into discrimination, then there are obviously risks to employers. Now, there is the financial cost to businesses that they would need to consider in respect of claims being issued against them in the employment tribunal. So for discrimination claims, the compensation that an employee or a worker may obtain is uncapped. It's based on what we call the Vento bands, named after the case in which they were first reported. But ultimately, compensation can be uncapped. And looking at the tribunal award statistics in 2022-2023, the disability discrimination actually had the highest compensation awarded, which was in the region of 1.7 million. So that shows the level of compensation that can get up there. It's not always that high, definitely not. But there is a high level of potential financial risk there. And there are also a lot of other implications that employers obviously consider in terms of not just a legal obligation, but a moral obligation to prevent discrimination in the workplace. So other implications that businesses may suffer from as a result of discrimination or unwanted banter could be increased sickness absence if employees don't feel able to come into work, or potentially the working environment's having an impact on their mental health. Loss of valuable members of staff, so people might, as Adam said, ultimately raise grievances or just decide to resign if they don't feel they can carry on in the workplace. There could be decreased staff morale, which can affect efficiency in the workplace as well, which again has further ramifications for the business. There is also potentially difficulties in recruitment, because if people understand that a business has a certain reputation and that they don't look at tackling discrimination or unwanted banter in the workplace, then potentially employees may not want to work for a business, and it could also even impact on customers or deals for that business. So ultimately, it's vitally important that employers take appropriate action to tackle discrimination in the workplace. And there are a number of ways in which employers can do this. So one of the key ones would be putting in place clear policies to show the employer's position on discrimination. So a key one of those would be an anti-harassment and bullying policy. So what that would cover is the definitions of discrimination and harassment and victimisation, like we've talked about today, and show what an employer does to tackle that and what steps employees can do if they feel they've faced bullying or harassment in the workplace, and what support they can have internally as well as externally. So internally, that would look at potentially support from their colleagues, but also formal processes such as raising a grievance, as Adam mentioned. And then the employer needs to make sure they have a clear disciplinary policy in place as well. So if there has been any unwanted conduct, so misconduct or even gross misconduct in the workplace, that formal disciplinary action is taken as appropriate as well.
And increasingly we're seeing amongst our clients as another way that employers are looking to guard against unwanted banter in the workplace is training on issues such as we've talked about today, what discrimination means, how it can impact on the day-to-day running of a company and an employee's role. And we're often asked to undertake banter versus discrimination training, but also wider training on equality and diversity, or even on more specific topics like just harassment or just an aspect of disability discrimination, for instance. But also what employers and employees need to think about is that isn't just a tick box exercise. Employers shouldn't just do it once and then think, oh, I don't need to do that anymore. It's important that refresher training is happening regularly to ensure that employees retain that knowledge which they have gained. And when we say training, that doesn't necessarily mean sitting in a big room with two solicitors stood at the front of it with a PowerPoint presentation. Training can be informal, it can be fun. So for instance, we had International Women's Day last week, we have the start of Ramadan, and employers can do things to raise awareness of different cultures, ethnicities and backgrounds that educate other employees on those things so they feel more equipped to deal with different cultures and employees across a business.
And I think what's important to point out as well, we've talked a lot about businesses and the risks that they might face if there's discrimination or unwanted banter in the workplace. But employees should remember they can also be held personally liable as well in an employment tribunal. So they can be named as a respondent by a claimant in an employment tribunal as an individual who has discriminated against them. And if the business themselves has taken reasonable steps and to tackle discrimination in the workplace, that might provide them with a defence to an employment tribunal claim. So the responsibility is on everyone in looking into that. So it's both the legal duty, but also, as we said, the moral duty as well, to make sure the workplace is an inclusive place for everyone and that everyone wants to keep attending the workplace as well. So I think that's probably long enough for us to go on about sort of discrimination and banter. But if you have any other questions, please don't hesitate to get in contact with the team. And thank you for joining us on our podcast today.